When a police officer is murdered, it makes news. When his girlfriend is charged with the murder, it makes big news. But when his girlfriend says she was framed by police who are the real killers, it makes huge news. And that is the story of Boston police officer John O'Keefe and Karen Reed. John was killed and left to die in the cold on the front lawn of a fellow officer. Karen is on trial, accused of purposely backing her SUV over him, and the lead investigator in this case was attacked by the defense as a biased trooper who was out to get Karen and to protect his brothers in blue. Now, 70-plus witnesses have testified, the attorneys have made all their arguments, and now it's time for the jury to speak. We'll break down all the latest as we continue our investigation into the tragic death of Boston police officer John O'Keefe. I'm Vinnie Politan. Thank you for joining us. Here we are, still waiting for the verdict from the jury. They did almost a full day of deliberations today. Left just a little bit early because one of the jurors had an issue. But the bottom line is the jury is working through this case. We're not getting a super fast verdict. It just didn't happen here. I know there was a lot of clamoring, people saying, oh, this is they'll be done by Tuesday afternoon. No, didn't happen. Didn't happen Tuesday afternoon, didn't happen Wednesday. So tomorrow's another day the jury will be back to work. But even though the jury doesn't reach a verdict, things happen during a verdict watch. This is the time when we do the proverbial tea leaf readings, right? Let's read those tea leaves. What's going on here? Well, and sometimes it's a little more obvious than other times. But the bottom line is things are happening. So let's take a look at what happened today as the jury came in for day 2 of deliberations, and the lawyers and the judge went at it.
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
You said before you were tired and you needed to think about it was you agreed that there needs to be not guilty options for the subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury, is exactly how it always is in Massachusetts.
I ask you a question then. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate. It's appropriate.
Make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict form?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty, and on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for lesser included.
Okay, I disagree with you. All right, excuse me. This is funny, Ms. Reed. All right, we're done. There are some minor changes that need to be made to the verdict slip. Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
All right, so it will be not guilty. So tell me again how you want it.
Sure.
You want
Not guilty of the offense charged or any lesser included offense.
So, big argument today about that. So, let me show you the old verdict form so you get an understanding of what we're talking about here. If you take a look at it, you've got count 2, manslaughter while operating a motor vehicle under the influence in the above titled case. And then you've got not guilty as a choice, guilty of the offense as charged. And then there's 2 that are indented. And that was the problem. They felt like if you found not guilty of the offense as charged, you would check not guilty, and then you go to the lesser included, and there's only a guilty line for those 2. Guilty of lesser included offense of involuntary manslaughter. So the form of it was really the problem, the confusion. They end up fixing it by making the top not guilty of the offense as charged or the lesser includeds. But there's a lot of arguing about this. So let me bring in our guests, all of them from Massachusetts, all of them spending a lot of time in criminal courtrooms trying cases and winning cases. Joining us, criminal defense attorney Joseph Krowski Jr. Also joining us, criminal defense attorney and college instructor and author Peter Ellikin, and the former head of the homicide unit in the Norfolk County District Attorney's Office, attorney Rick Grundy. Great to see everyone tonight. All right, Joseph, you had Mr. L.A., you like to call him Hollywood Jackson, not happy with the Massachusetts verdict form or verdict slip. Do you think this was a big deal to not have clarity about the lesser included charges?
Look, I think those 2 probably need couples therapy at this point, but I'm glad they worked it out at the end. No, that is typically the form we use. It's really not that confusing. The reason there are not any not guilty boxes on the lesser includeds, because the jury's instructed if you check off not guilty, you don't even consider any of the lesser includeds. I agree mechanically the way that form looks is a little confusing. The standard form in Massachusetts usually says only check 1 box. But typically you don't have a not guilty option on a lesser included offense, because if it's not guilty of everything.
Everything.
So this was kind of much ado about nothing, but it's zealous advocacy. And look, to her credit, after she thought about it, she changed the form.
Yeah, well, Peter, I'm looking at it, and I try to look at it this way. I mean, we're all lawyers. They're all lawyers. The 12 people in the box are not lawyers. They're ordinary folks. And I think between the jury instructions and everything else, I think we're a little unfair to the members of the public sometimes, and we presume things. Like in my state of New Jersey, where I practiced, and I don't know what they do in Massachusetts, the jury instructions don't go back with the jury. They just hear them. They hear them once, and then they go decide a murder case. So I think more clarity is always the best choice. Simple and clear.
Yeah, I agree with you 100% that I think Judge Cannoni, and it was nice at least to see that she was flexible. It looked like she was not going to go with it, but she did. And anything we can do to make things more clear and less confusing to the jurors is all to the good. And it was also a smart decision on her part. If ultimately Karen Reed is found guilty of anything or one of these lesser charges, that would have been an appealable issue. Now she killed. There's no chance of appealing on that issue. And I just think, again, anything we can do to make things clear for the average lay person and just concise and easy to read, that's definitely in the plus column.
All right, Rick, unless you want in on this, I think we've dealt with it. The jury also asked for the cert report today, right? They came in. They're looking for that cert report, which is the report relative to the search for these taillight pieces. Can you read that tea leaf for us tonight?
Well, I think, obviously you can go different directions with it. I know that Nick did point out, and I do recall this testimony, that there were, from opening to the actual evidence of the discovery of these taillight pieces, there was a difference in the numbers. Maybe somebody seized upon that. Regardless, I think for both sides, they put this forth, the finding of these as strong evidence for their side. So I think I think the jury could have landed there just because it was something that they started discussing and there was some discord and they said, hey, there's a report, let's get the report, and that'll settle it, because that's what logical people would think. But we're in a court, we're not dealing with logic.
We have about 20 seconds, Joseph, just 20 seconds. Your thoughts about that request by the jury to get that report, which they're not getting because it's not in evidence.
It's not in evidence, it's hearsay. Typically, they don't get it. What I like about it is they're looking at every aspect of this case, including the technical aspects of the case. There's also information that the CERT team was there while Karen's car was at the Sallyport, the Canton Police Department. So, either side could probably look at it as a positive, but really it's just rank speculation at this point. It's an 8-week trial with 70 witnesses, 200 plus exhibits. No, I didn't expect a verdict today. They're doing their due diligence. They owe both sides a long and thorough deliberative process.
Absolutely. All right, good news, folks. Everyone's staying for the hour. Up next. A shocking moment in the courtroom as the people accused by the defense of being responsible for the killing of Officer John O'Keefe take a seat in the courtroom with the loved ones and family of John O'Keefe. What impact will this have? On the next episode of Accomplice to Murder.
It looked like Virginia and Norman really had a wonderful relationship.
But then greed planted the seeds of a brutal murder.
$1.1 million in benefits to Virginia.
And when she couldn't find a hitman, she decided to use her son, Jason.
She said, no one is going to be getting in the way of me collecting that insurance money, or they'll wind up just like Norm.
Accomplice to Murder with Vinnie Politan. All new episode, Sunday night, 8, 7 Central.
Only on Court TV.
And your thoughts on changing to the smaller courtroom?
I think it's great. It's more intimate. It's more in keeping with what you would expect a traditional courtroom to look like, and I'm very happy with it. I'm very happy with it.
So before the trial, there was a switch of the courtrooms inside the courthouse for this major trial, right? Major trial, major interest. The original courtroom where all the pretrial hearings were, that was the big, beautiful, historic courtroom. Lots of room for everyone. All the big trials in Dedham, this is where you have them, including like Sacco and Vanzetti was in this courtroom, for goodness sake. But Alan Jackson didn't like where the witness stand was in relation to the jury box, so they ended up with courtroom number 25. Let's take a look at courtroom 25. Let me take you inside there. And this, ladies and gentlemen, is a much smaller courtroom. It's tiny. Look how on top of everyone, each other everyone is as you walk into courtroom 25. It's a smaller courtroom. So let's take a look at it from the perspective of the witness box, right? And we could drop those little letters there. So when you look from here and you see the jury box on the left, I want you to understand what the jury is looking at and how close everyone is. So let's take a look at who is sitting where in here. So where the red is, that's where Karen Reed, her family, friends, and supporters are. But the jury is staring directly, and it's small, so they're like right there at John O'Keefe's family, friends, and supporters, and then the media is up on stools behind them. Now, so why is that a big deal? Well, take a look at what happened during closing arguments in this case. Who is sitting in those seats, right in the view of the jury with John O'Keefe's family? oh my goodness, some of the witnesses from the case, the people that the defense is pointing the finger at as being responsible for the death of John O'Keefe and the cover-up of all of this. We're talking about Jennifer McCabe, Brian Albert, Colin Albert, all right in front of the jury during closing arguments together. So, what's the impact of this, if anything? Let's bring back in our special Massachusetts think tank. Peter Ellikin, what do you think of that?
Oh, absolutely, definitely a strategic move. Hey, you heard us testify. We're here. We're watching you. And here we are next to the O'Keefe family. So get the idea that, you know, if you convict her, that kind of honors and brings justice to the O'Keefe family. That can also be misleading because that argument, I know the opposing side would be saying, yeah, but if you convict Karen Read and she's truly innocent, then you're not bringing justice. You're doing two things. You're creating a new victim, and the real guilty parties are going away. But a sharp strategy on the parts of the Alberts, I'd say.
Rick Grundy, if the accused killers and cover-up are seated with the victim's family, I mean, what is the message to the jury here from the prosecution and from the O'Keefe family?
Yeah, so initially I was like, ooh, I don't know. Do you want to bring the jury back to those hellish days when they were slogging through those witness after witness? But as I thought about it more, I thought, you know, I think it's a good idea because I think particularly the prosecution really didn't bring John O'Keefe into this trial the way they should have. And they had these two living, well, plus his brother. So at least 4 people of his family there every day, and he didn't really draw them into it. So this accomplished that, if nothing else. Of course, on the other side of the coin, you know, somebody's going to be looking and saying, well, you know, who isn't there? Oh, Higgins isn't there. I guess Higgins did it by himself.
Joseph, what are your thoughts? And again, at one point you did represent Colin Albert.
So I think that this is really a message being sent by the O'Keefe family where they stand. The O'Keefe family, I think, is telegraphing to the jury that they don't buy into the cover-up, that they support the Alberts and the McCabes. Really, as it relates to the courtroom, this is a case of huge public interest. I hate the decision to hold it in Courtroom 25. I think it violates the right to an open and public trial. The way this process has been working out, Karen Read has her section. It seems like she can invite people to her section. The O'Keefes have their section. They can invite people to their section. It has nothing to do with Karen Read and the O'Keefes. The public has a right to be there. We shouldn't have just 10 people from the press. Poor Matt camping out in a chair 12 hours through the middle of the night, not getting good sleep. It should have been in the bigger courtroom. But I think this is a message from the O'Keefes that they don't buy the cover-up. And it's a message to the people that were the target of the third-party culprit defense saying, we've got our head held high. We have nothing to hide. We didn't do anything, and we're here. We're not hiding. We're here front and center for all to see.
And we've got to clarify, Matt Johnson doesn't sleep outside. One of our producers did, Tiffany, was sleeping on the sidewalk so Matt could get in there, right?
Well, you're awfully mean to Matt sometimes, so I made an assumption.
Right. No, I'm not. I am never mean to Matt. Rick, that historic courtroom, all the big ones were there. I mean, all the big cases that you tried were in the big courtroom, right?
Absolutely, absolutely. Yeah, I don't know if Jackson thinks that that's a nice intimate courtroom that he's in. He must love to ride the city buses. It's ill-equipped, it's ill-fitted. You can see it's countered just so that they can get a bench and 2 tables for attorneys into it. The only good thing about it is as you come in that door, right to the right, there's a bathroom.
So, Peter Ellikin, do you think this, and because if you're in that big courtroom, you're not going to have a situation where the jury is staring at the victim's family for 9 weeks. I mean, for 9 weeks, they are just, I mean, you sit in your seat directly across the room, very small room, is in fact John O'Keefe's family.
I mean, to me, there's a sense here that maybe it backfired. You're better off in the big courtroom. Everyone's spread out. You don't know who's there for who, and there'll be members of the public mixed in. There's none of that.
That's true. Sometimes when I have, in very short legal proceedings, when family will show up and say, we want the judge to know we're here, and they're even lost in the crowd, and it's almost like a waste of time. I do agree with what Joe said about it's really regrettable that you don't have a large courtroom open to the public. We do have public trials. However, I will say one little thing. There is a saving grace that this trial was live streamed, so the entire public could watch it from the comfort of their home or anywhere. So that's a bit of a saving grace. It wasn't like the public was shut out and we just have to, read about it in the newspaper or something. So it was as public a trial as I've ever seen, but it would have been much better in the large courtroom where they burned Sacco and Vanzetti.
Hey, by the way, innocent Italian Americans, Sacco and Vanzetti.
I agree.
Yeah.
One of the injustices of American history.
Absolutely. Joseph, 15 seconds here, just 15 seconds. From your perspective, do you think it's sunk into the jury, though? Do you think the jury considers those things like the family? 15 seconds.
They do. I mean, how can you not? They know who they are. And this is the unique circumstance. Those are witnesses that testified in front of them within the last 3 to 4 weeks. So certainly, I think it has an impact. It's not supposed to. They're supposed to decide the case on the evidence, but it does.
Up next, lead investigator Trooper Proctor admitted on the stand that he took part in regrettable, inappropriate, and unprofessional conduct during the investigation of Karen Reed. So, what happens next to Trooper Proctor? And what about the other murder cases he has investigated? We'll take a look.
Your assessment, personal assessment, that Karen Reed had struck this officer with a car gave you license to call her a
It was my emotions had gotten the best of me.
and you called her a whack job. Gave you license to call her that too.
Yes.
Gave you license to say to your friends, oh, no. She's right?
That's what I wrote.
Gave you license to say that she's a
Again, another disgusting comment.
You get to talk about her leaky balloon knot, right?
Objection.
One of the biggest moments in this trial, the testimony of Trooper Proctor, and I think because we heard things that we don't normally hear in a case like this from the lead investigator. He was on the stand. The direct, he went through it, and then the cross-examination went through it as well. So Trooper Proctor obviously kind of caught doing things that are very, very unprofessional, to say the least. Caused, people protesting Trooper Michael Proctor with signs like "Michael Proctor hates women." Then we found out that it was announced on March 14th that there was opened an internal investigation into a potential violation of department policy by Trooper Michael Proctor. Trooper Proctor remains on full duty. But then there's more to this, right? Because this is not his only case. There's another big trial that we're tracking here on Court TV, by the way, involving a man named Brian Walsh. There he is inside the courtroom. He's accused of murdering his wife. And it's in the same courthouse. And Trooper Proctor is the designated case officer for that murder trial as well. Take a listen to some of the evidence in that case.
It had become evident that Mr. Walsh was suspecting his wife of having an affair. The oldest child's iPad begins to visit websites concerned how long does it take for a dead body to smell? How long does it take for someone to be missing to be declared dead? He is seen purchasing numerous items, including a Lennox high-tension hacksaw, 48 terry cloth towels, 200 disposable rags, trash bags. In the Swampscott dumpster, they found items, including a set of Volkswagen keys, Anna Walsh's COVID vaccination card. Also located in the dumpster, Your Honor, were rugs. These rugs contain red-brown staining as well, and a piece of a Gucci necklace consistent with one that Anna Walsh wore.
So what happens now? What impact does everything that was revealed during the course of this case have on the rest of his cases, the rest of his career, prior convictions of people he investigated? Let's bring back in our special Massachusetts think tank. Rick Grundy, let me start with you. What are your initial thoughts here about what impact this will or won't have on other cases like Brian Walsh?
So the short answer, it'll haunt him for the rest of his career, as it should. Let me just remind you viewers, we've talked about this before, and obviously our other guests know that, but in Massachusetts, this is a highly prestigious position, and the troopers that get into the homicide units are a part of the district attorney's office. They're housed there. They're answerable to the district attorney. So starting with this current trial, the fact that he took the stand and was still in his position prevented the prosecutor from at least being able to say, and you were removed from the district attorney's office due to these actions. And now the district attorney's office doesn't have a say as to what Mass State Police do, but hopefully, and you were suspended. But this is what has been going on with what's called in Massachusetts the post filings, where they are created a whole registry of police violations. So like the others that end up on the post list, this gentleman's, these actions will follow him to each case. Mr. Walsh is wrapped up tighter than a pig on a spit, so I'm not worried about him. But the bottom line is Proctor should be removed for cause, and he will be ineffectual.
Joseph, your thoughts. What's going to happen? Does this impact any prior convictions involving him as an investigator?
Oh, absolutely. There was just recently a motion for a new trial allowed on a murder conviction down here in Plymouth County because it was revealed that the prosecutors had been exchanging anti-Asian emails with one another, inappropriate emails regarding anti-Asian prejudice. And Superior Court trial judge allowed the motion for a new trial because of the bias of the prosecution team. So I think there's going to be the same problem here. And if I understand Rick correctly, he almost thinks it would be better if the prosecution could say, you were removed from the district attorney's office. That's an awfully double-edged sword. I think if he gets demoted or fired, which he should, it's going to taint every case he touched. Now, in the Walsh case, if he's the primary out of CPAC on that case, the playbook has already been established in this case. If this jury buys the cover-up with the architect being Proctor, here we go again with Walsh, because who's not to say that he didn't get his hands on those tablets and enter in different Google searches? So this is a problem for past cases, this present case, and future cases.
Peter Elkin, will every defense attorney now try to get his phone and all of his messages and all of his history?
Oh, well, they'll be lined up for that. You'll have to take one of those like bakery things just to hold your place in line. I go with the conventional wisdom here that I just don't see a path to him ever continuing with his career. And even if hypothetically Karen Reed is convicted of this case, that would not sort of exonerate or legitimize him at all. I just think, and I agree with what Rick Grundy just said, that I think the Brian Walsh case is really such super strong evidence. I doubt it's going to stop him from being convicted, but I can just see every case he's ever been involved with, people who are either in jail now or convicted perhaps years ago, they are going to be lined up like at a subway turnstile, just waiting their turn to do the appeals and see what happens. And I just can't imagine him remaining in this job.
Joseph, another big issue in this case is the federal investigation that was taking place, right? This is where a lot of this information came from. But there's a lot of confusion in the public and some right in this studio that I'm sitting in with me. Like, what what is the impact? What is the end game with the federal investigation? Is it over? Is it going on? Is someone going to get in trouble? Does it have anything to do with the alleged conspiracy? What exactly do you see as the final bottom line with this federal investigation?
So look, this is maybe not unprecedented, but certainly unusual. There have been cases in Massachusetts where there was evidence of police corruption, evidence of police malfeasance, and the feds didn't take the time to intervene and investigate. Of course, most of those cases involve black and brown faces. They don't involve a white suburban professor. They have no jurisdiction over the murder charge, but it's really important, and it bootstraps into what we were just talking about. That's how they got Proctor's phone. They have oversight because they have jurisdiction over civil rights violations and police corruption. It's tough to say what they're going to do. If they were going to charge someone, I don't think that they would let them testify in a murder case and just wait and sit on it and bring charges afterwards. But I also wouldn't be, resting too comfortably if I was Michael Proctor. It's tough to say. But again, the really interesting thing about this case, they might not know it, but a lot of the Free Karen Read people have really aligned themselves philosophically with Black Lives Matter.
So, Rick, this case, from my perspective, the most compelling evidence that was brought forth from the defense was basically handed to them by the federal investigation. The text messages from Trooper Proctor and those two experts at the end of the case. So the feds impacting a state case, but actually helping the defense. How strange is this whole dynamic?
Yeah, I'll take it one step past what Joe said. I think it is completely unique as far as my memory bank is concerned. It certainly is. In trying to answer these questions for myself, I thought, the Higgins aspect of it, who's a federal law enforcement officer, and destroying his phone in the manner that he did, that's going to bring in federal inquisitions, whether it be from his own unit that he worked for, his own particular department, and they reach out to the U.S. Attorney's Office, or the U.S. Attorney's Office finds it on its own. But then when they start doing the accident reconstruction, are they going to do an accident reconstruction if they're just looking at Higgins? No. Are they going to do an accident reconstruction if they're looking at Proctor for possible civil rights violations? Potentially, because of the different things with respect to the allegations of covering up, moving evidence around, whatever. But I can't tell you how much good faith I lost by telling people this trial's not going to start. This trial's not going to start. The feds are doing something with it, and they're going to step in and screw the whole thing up. But
well, I don't know if they screwed it up, but they certainly helped the defense. All right, guys, stay where you are, because coming up next, our lightning round. We're going to go through some of the evidence in the case and have our experts tell us, how important is it?
There was pounding on the door. Bang, bang, bang.
He said that we'd seen his face and there was no way that he could ever let us go.
I survived because I'm a born fighter.
I Survived. Next on Court TV.
It's a controversial case that's divided a community.
Karen Read is accused of murdering her police officer boyfriend. Will the truth finally be revealed?
The killer or cover-up murder trial. Weekday mornings, only on Court TV.
I got one more thing. Can we all take just 1 minute of silence for Officer John O'Keefe? Thank you very much. Guys, enjoy your day.
And there you see and hear some of Karen Read's supporters honoring Officer John O'Keefe and waiting for this verdict to come in. Welcome back. Right now it's time for our lightning round. We're going to work through a bunch of pieces of evidence with our Massachusetts think tank. The rules are simple. Each guy will have 15 seconds to tell us 0 to 10 how important is the piece of evidence, who is it important for, and why. Joseph Krowski Jr., Peter Ellikin, and Rick Grundy still with us. And if we run out of time, guys, I've got a bell tonight, so we'll be ready to go. Let's get to our first piece of evidence, which is that Karen Reed is the one who found John O'Keefe and knew where his body was. Take a listen.
And your testimony was, as you approached, my client was searching frantically for John O'Keefe.
I don't believe I said she was searching frantically for John O'Keefe.
Searching frantically?
She was screaming frantically in the back seat and texting in the back seat.
Was she just sitting there, curled up in the back seat, sucking her thumb, or was she searching out the window?
She was screaming between Kerry and I. So I'm not really sure how she saw John over here when her head is up here screaming and then looking down and texting.
Was the whole point of that trip, Ms. McCabe, to search for John?
It was, because she knew where he was.
Joseph Krowski Jr., 0 to 10, how important is this piece of evidence?
That's a very important piece of evidence. That's an 8 for the Commonwealth. If you couple that with Kerry Roberts' testimony that Karen Reed called at 5 o'clock in the morning and said John is dead, supposedly prior to her ever going back to 34 Fairview, and the data that shows that there is a good chance she drove to 34 Fairview before going to Jennifer McCabe's house.
Peter Elkin.
Yeah, on the face of it, I'd say maybe a 4 for the prosecution. It's kind of a wash. The fact that they drove up there and she's sort of the first one to spot. I mean, it's not that big. It wasn't a mansion with a massive lawn or anything. They're looking for him. The whole point was to search. And the fact that she saw him first, and then people are saying, oh, that must mean you knew where he was. I don't think that really carries. So maybe it's a slight plus for the prosecution, but it's not conclusive at all.
I'm going to go right in between there. I give it a 6 or 7, largely for the same reasons Peter did, is that it's going to depend on the leanings you have developed, whether you're going to give this witness credibility or not. More so where you're leaning than what you're hearing.
All right, let's get to our next piece of evidence, the cuts on John O'Keefe's arms.
Based on your review of all of the data that you've talked about, all of the information that you were given and reviewed, what is your opinion or conclusion about how these injuries were sustained?
I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries.
Peter Ellikin, 0 to 10, how important is that evidence?
I think it's about a 7 for the defense. That they were able to bring on experts that said it was, in their expert opinion, it was a dog. And I know that's kind of negated. The other side had an expert saying the opposite, that they found some pig DNA or something, which, of course, then they could, defense could knock that and say, well, how do you know that's not a dog treat was in his mouth? And then they also brought on, the defense also brought on the expert saying, the Fed expert saying that, there would be evidence.
0 to 10.
The arm. I'd say 7.
I got to give that an 8 for the defense, because I just don't think the prosecution. I don't think the defense proved it, but I don't think the prosecution countered it all that well. But it ain't a dog's bites, I'll tell you that.
Joseph Krowski Jr., 0 to 10.
I'll give that 7 for the defense. I wasn't really impressed with the expert. Forensic canine bite pathology is a difficult thing. I didn't think it was a very sophisticated presentation. But to the eye, certainly it does conceivably look like dog bites. I don't think the Commonwealth did enough to explain how broken glass or the shards from the taillight could have, in fact, caused that injury.
All right, next piece of evidence, we're talking about the hair on the bumper of Karen Reed's SUV.
The mitochondrial DNA profile that was obtained from the sample, the hair sample, was consistent with the mitochondrial DNA profile obtained from John O'Keefe. So therefore, John O'Keefe cannot be excluded as a possible contributor of that hair.
Rick Grundy, 0 to 10, how important?
I put it right in the middle there again, a 5. I liked the evidence that it was frozen into the bumper when they found it. But again, this is, you're going to hear this with ears that have made some decisions based on evidence other than this. It's going to go whichever way you're leaning.
Peter Elkin, 0 to 10.
I'd say 1 for the prosecution. I think that, again, the jury's going to have trouble with credibility, that there's a hair not really attached on the side of a car, traveling 60 or 70 miles in the middle of a blizzard with blowing wind. However, even if you did believe it was his DNA, the fact that that's his girlfriend's car, their long-term girlfriend, I'm sure his DNA and his hair is inside the car, outside, all over the place. So I don't think that does anything for the prosecution, and I don't think the jury is going to give that much weight to it.
Joseph, 0 to 10.
Look, that's an 8 for the prosecution. If I couch that with, if you don't believe it was planted, but I don't believe Proctor would plant a hair on the side of the car. And even if O'Keefe had been in that car many times, to have that piece of hair linked by DNA right next to the broken taillight, if you don't believe it was planted, that's the case, isn't it? That's everything.
Final piece of evidence tonight, the accident reconstruction expert called by the defense.
In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you. That's all I have.
All right, Joseph, I'll start with you. 0 to 10, the accident reconstruction experts for the defense.
I think it was a 2. I think both sides were terrible. I think that Judge Cannoni let them give opinions that really aren't even part of expert opinion. Typically, you have to have your opinion more confined. It seemed like both sides were just ad-libbing. At least he had the intelligence to not go out too far on an island like the expert Paul did for the Commonwealth. But I wasn't impressed by either side's accident reconstructionists.
Rick?
I agree with what Joe just said. I'll give it maybe a 3 or 4 because he was better than the guy on the other side, basically. But no superstars in this stuff. And again, it's evidence that it's going to pull you in the direction you're already going, and that's its top quality. And you haven't had to use the bell once, Vinny, on me.
Not yet. Peter Elkin.
Oh, I already had the bell on me, but I'm wasting time. Yeah, I think that I'd give it a little bit more. I'd give it maybe a 6 for the defense, only because you hear the other side with their experts, and so maybe they kind of negate each other. But I thought he was rather effective, and I thought the idea that the defense brought in these independent guys, the jury had no idea why these weren't hired by the defense. Obviously, they can't find out that they were the feds. But they may have been impressed with it, that these are outsiders coming in and looking at it. But again, it may be kind of a wash because, again, battle of the experts, and we heard both sides. So that would bring reasonable doubt, but even. Don't ring me now.
I almost did, but I'm not. Go ahead, Joseph.
I go up to a 5. Peter convinced me. I think he was that much better than the Commonwealth's expert, but again, not overwhelming.
Look at that. Wow. Joseph Kraske Jr., Peter Elkin, Rick Grundy, your insight, your experience has helped us a lot tonight. Hopefully we'll see you again tomorrow night. We may or may not be talking about a verdict. We shall see. But in the meantime, folks, before we go tonight, we have a missing child who needs your help. Take a close look at the photo. This is Lois Elaine Epp. Lois is 17 years old. She's missing from Phoenix, Arizona since June 19th, been about a week. If you see her, this is what you need to do. Pick up the phone, make a call. You can always call 1-800-THE-LOST. You can always call 911. But you can also call the Queen Creek Police Department in Arizona. That phone number is on our screen right now. I'm Vinnie Politan. Thank you so much for watching. Make sure you're watching tomorrow morning for the Verdict Watch. It can literally happen at any moment. In the meantime, have a great night, and please don't forget to hug the kids.